as well. Very, very excited to introduce our next guest. He is a criminal trial lawyer, a former assistant U.S. attorney in Los Angeles, and always the most interesting conversations we have with David Katz. Welcome to the show, David Katz.
Great to be with you.
Hi. So I just read the story. Let's jump right into it. That there apparently was this effort to maybe negotiate a settlement. A lawyer said that they thought Merrick Garland might want to take an exit ramp to avoid charging a former president. And so they thought there was a room to negotiate a deal. But another attorney told Trump, don't take any deal, fight this one. And so no deal was made. But apparently there was some type of movement there for a settlement. Have you heard about this? And would that have been a smart thing?
Well, Trump could have said, I made a mistake. Other people made it. Why are they trying to pin something on me? I took a misdemeanor. It doesn't affect anything. I'm proud of my misdemeanor. And it would have avoided a lot of these allegations and so forth. And maybe he could have kept Corcoran's testimony completely secret. He could have kept his valet out of trouble. I mean, now his valet used to serve dinner. Now he's an honored guest at dinner because he holds the key to the jailhouse for his former master, right?
Yeah.
The valet now has this huge leverage, and Trump has to treat him like gold. He could have, just let him be his valet, and if he'd have taken this deal. But I think that the dynamics of it were that Trump wanted to defy it. There was a part of Trump that kind of taunted the Department of Justice to charge him. I mean, the way he acted, you could say, he didn't need to make a deal at all if he'd have complied with the subpoena and given the stuff back. Of course, if you look at Trump, Kim, I think it's very possible that he wanted to use those documents to his advantage, and giving them back, he couldn't use them to his advantage. Also, if it were well known that there had been this subpoena or it leaked and he'd given everything back, he sort of had this like blackmail ability with people, this idea that if you come after me too hard, I've got something about you that I not only know about, but I could release it, I could leak it. So we think that Trump probably used these documents not only to show off, not only to play, that like he was still the big guy, he was still in charge. Look at the documents that he had, showing them selectively to people in a way that would impress them. But we think, of course, he tried to monetize everything. And so we suspect, we're scared, and the Department of Justice was scared that he was showing them off to the Saudis, showing them off to other people for political influence, for money, for those kinds of things. So I think that from his calculus, he was never very interested in trying to make a deal in this case, even if it had been a deal that guaranteed him not going to jail. And so I just don't think that apparently the $3 million man, I can hear Trump right now saying, wait a second, I just paid you $3 million and you want to plead me out? Go work for the money, for God's sake. Fight a little. And that's this guy, Kise, Kise. But I think the reporting was that he got the $3 million and then he gave that advice that, maybe you ought to just plead in this case. Yeah. I'm often in cases where people decide not to plead guilty and they want to actually fight the charges. So I've been there and I've heard those stories. I gave this other lawyer $1 million and he said, I can get you a great plea deal. I can get you 2 years in prison. And the guy was, if I wanted 2 or 3 years in prison, I want to defend this case. I want to hire you, Mr. Katz. So I've been there. So I don't really fault Trump so much, Kim, that he didn't go for that deal.
So you talked about Trump's kind of big mouth and what he was saying. And this question comes from Mark. He was wondering if there are any restrictions on what Trump is allowed to say, because you hear him, even after the arraignment, after his appearance in court, he comes out and he's spewing all these lies and talking about the case. Is there any possibility of a gag order, or are there any limits to what he can and can't say about what's happening legally?
Well, the special counsel is being tarred with this brush that it's all political, which is really kind of far out because he's apolitical. He's not a registered Democrat or Republican. He was at the World Court. He's been a prosecutor for years. He seems like just the kind of apolitical person who should be on this case. And if you wonder why the case is in Southern Florida, at least certainly in the court of public opinion, there's the argument that he bent over backwards to be fair to Trump. Right? I'm bringing this case in your own backyard. I'm bringing this case where you're going to have a blue and red jury, not the 95% Biden voting jury that you would have had in Washington, D.C., because I think he clearly had venue in Washington, D.C., could have brought this case in Washington, D.C. And if you look at it from that point of view, knowing he had 1 in 3 chances of getting Judge Cannon down there in the West Palm Beach area, he certainly bent over backwards to be fair. So your question again was, I'm sorry, what can be done? So he doesn't want to look like he's restricting Trump. He doesn't want to play into the narrative that, you see, they're prosecuting me just to hobble me. They brought these charges against me just to make it hard for me to run for president. So that's why in the normal case where someone has to turn over their passport and then get this huge approval from the prosecutor and from the pretrial services officer, Trump's not going to need that. If he wants to go to Israel for some campaign event, if he wants to go to Canada as part of something, wants to go down to the border, he's not going to need any permission for that because they don't want that kind of argument. Actually, the prosecutor said that he didn't want any conditions, no travel restrictions, no nothing. And the magistrate judge brought up, well, wait a second. Normally in cases, we always have this condition that you can't talk to your co-defendants about the case itself. So the magistrate judge did impose that condition pretty much on his own. He has this valet we just talked about who's charged along with him, Nauta. So Nauta and he are prohibited from talking about the case. They have to do that through their lawyers. There'll be a list of some other major witnesses in the case that he'll be prohibited from talking about the case to. How can that be enforced, Kim? Well, the way it could be enforced is that somebody later on becomes a government witness and says, hey, on this and that date, I talked to Trump about the case. And that was a month after Trump was ordered not to talk to witnesses like me about the case, but to only go through the lawyers. Now, on top of that, some people worry because of the example with Roger Stone, where he put the crosshairs of his federal judge online. And then he had all kinds of explanations. And the judge hailed him into court in Washington, D.C. And she said, you better explain this really quick, why you put my picture on the internet with crosshairs behind me, because that could be really dangerous. That's not what our system of justice or respect for the law is all about. And Stone got on the stand, if you remember this, and he gave a whole bunch of testimony that somebody else got a hold of my Twitter or my social media posting, and who was it? Well, I don't remember. Or how long ago was it? It was a week ago. And the judge says, look, I don't believe you. And I think she said to him, there's no 3 strikes in my court. So you've had 1 strike. You have another one. And she restricted him from making any comment about the case. And it was very controversial. And you wonder if he'd have taken that case up to the appellate courts, if maybe Stone would have won. But Stone was way behind the 8 ball for having posted that, it's basically a tacit threat to the judge on his case. Trump's not going to be stupid enough to do anything like that. So he's not going to be in the position that Stone was in, that Stone's alternative to that big restriction on his otherwise First Amendment rights would have been that he would have been remanded to prison, and the judge would have done it. A judge's not about to remand Trump to prison anytime before the 2024 election, but he'll be smart enough not to do something like that. In terms of other restrictions like that, you remember how he blasted that federal judge on his Trump University case? Said he wasn't born in the United States, or all this kind of nonsense. By the way, Judge Cannon down there that he's got on his case, she wasn't born in the United States. But I don't think they were going to hear the same rhetoric from Trump about Cannon that we heard about the judge on the Trump University case. And people thought, wow, that was really sort of beyond the pale. It was a civil case. How much do you do about it? So I think that he's going to continue sort of blasting the process, Kim, saying how unfair it is, how he's being railroaded. He's going to make some choice remarks about the prosecutor, as he already has done. I think he called Smith deranged, for which, of course, there's not one shred of evidence. That's just outrageous rhetoric. But apparently he will be allowed to engage in that. He'll be allowed to say a lot of things on the hustings. And so the reality for the people who think this is going to restrain him, it's not going to restrain him. One last thing, in the New York case, you remember there's a protective order, and there will be a protective order in this case. So he's got a right to look at the discovery, but they're going to talk about that. I have that come up in my cases. That's very common in federal cases and in a lot of state cases. Nobody is singling out Trump. But once they give you this discovery and it shows, confidential things, it shows what people are saying, you have a right to it because you have a right to confront the evidence against you. That's different from saying you have the right under the First Amendment to go put it out on the internet or blast it to the world. No, you have a First Amendment right to what you come by, like journalists do.
Yeah.
But you're coming by that only because of discovery and only because of your right to confront the evidence and be part of your own defense, which Trump, like every other criminal defendant, has that right. But this is very normal that criminal defendants. I've had cases where my client, even in a white collar case, even where there was no specter of danger, was told, you can only read the stuff at your lawyer's office. That was a huge inconvenience. We got that condition in my most recent case modified so that my client could read the discovery, anywhere. But even though he could read it anywhere, it didn't have to come to my office. He's still under the same protective order not to disseminate it. So that is one thing. And that's important. They're talking about like the recordings, that people might have had, like an expurgated, unabridged recording, may have some very personal stuff on it. And, if Trump is going to send that out to the world because he got it in discovery, that would be a contempt of the court. So I think Trump will be careful not to do that because he doesn't want to get hailed into court on contempt charges. He acts like he would like that, Kim, but he doesn't really want that. In part, it will disrupt his preparation. The reality is he doesn't have to spend hardly any time in court. His lawyers are going to spend a lot of time in court. He can go out on the campaign trail and say how much he's being impeded and how much this gets in his way, and they want to drag him into court. But he has to show up for his arraignment. He has to show up for almost nothing after that except a trial. And in my opinion, the trials will all be after November 2024, if there are any trials.
You mentioned Judge Eileen Cannon, and there have been a lot of calls for her to recuse herself on this one. She's a Trump-appointed judge. And I wonder, is there any scenario in which she does that? Or does she think she holds strong and says, nope, I'm here, this is my case, I'm doing it?
I'm going to ruin the entire news cycle for a lot of your listeners and viewers. But the reality is that federal judges are as close to gods and goddesses on Mount Olympus as we have in society. They have life tenure. We presume, sometimes against reason, that they're incredibly fair and unbiased. And that will be the view that the Court of Appeals takes, that each one is a gem, fair and unbiased, and you better show some very compelling evidence how biased the judge is. Now, judges can self-recuse, and that's what I think they may be asking her to do. And like the New York Times already started with an article how unbelievably unprepared she is to be a federal judge. By the way, we have some very interesting people to thank for her. Apparently, some people treated this, and this is what makes people a little crazy about identity politics, even if they agree that women should get ahead, minorities should get ahead. But when you see a minority like Clarence Thomas put on the Supreme Court, you kind of shake your head like, wow, how did that work out, having an African-American justice on the Supreme Court? One of your viewers wrote and said, has he ever ruled in favor of Black people? But I digress, because Cannon got the votes of many female senators, or got the non-opposition of many female senators. Feinstein voted for Cannon, knowing she was from the Federalist Society, knowing she was a Cuban American endorsed mightily by Rubio down there, knowing that she was only 38 years old and had very, very little trial experience. Feinstein voted yes for her to go on the federal bench. Castro, the Nevada female senator, a Democrat, Castro Moti, whatever her name is there, she voted for Cannon. Yeah. I mean, 30 years from now, when Cannon has proven to be an absolute disaster, they'll remember that Feinstein and the Nevada Democratic senator voted for her. There were some people who didn't vote on Cannon, who was put up after Trump had already lost the election. She was put up after the November election in 2020. Vice President Harris was still a senator. She didn't vote against Cannon. And there are many others who didn't vote against Cannon. So they got to really watch these people who come up, and they got to vote, not like Vice President Harris did, not vote on her, vote against her. Yeah. She should have been voted against.
It was Senator Catherine Cortez Masto of Nevada.
Masto, excuse me.
Yes. So a lot of people I've heard talk about espionage and are confused as to why these charges come up as espionage charges in this 37 count indictment. And I think even Trump was saying, the cut of him saying, Yeah, he made this comment in North Carolina. He said, "They're going after me under the Espionage Act. That's like the creation of missiles in your basement." So, can you talk a little bit about why these charges fall under the Espionage Act and help people understand why it makes sense?
Other people who had lesser access than him, had fewer documents, who didn't have things like nuclear secrets, they have things like the war plan on Iran. If we were to attack Iran, there's a war plan. I mean, that's what the military does. They make up plans for various attacks, counterattacks, how people would attack the United States. Those kinds of plans that he had. He had one of them in his hand, and he showed it in, I guess, 2021, I think it was, at the Bedminster Club out in New Jersey. And he said, I used to be able to declassify this when I was president. I can't do that now, but it's still secret. Think how that undercuts every single one of his baseless defenses. That he declassified them, he said out of his own mouth, this is on tape, no, I didn't declassify it. He also showed a map to somebody and he said, now you stay back from that. You keep away from that map, so the person couldn't actually see the map's detail. And yet he was admitting that he had it in his hand. And that braggadocio, his defense is going to be, well, everyone knows I'm a liar. So I told the guy I had it in my hand, but I really had, my lunch list for that day. That's his defense, that he's such an inveterate liar that you shouldn't believe your lying ears, what he says on tape. He's absolutely overwhelmingly guilty from what I've seen so far in this case, which is why at the end of the day, Trump does not want to push this case to trial. You remember that Jack Smith said that he wanted a speedy trial. Well, he may want a lot of things, but I don't think he's going to get a speedy trial. And in part, Kim, it's because there are so many issues in the case. They're going to go back and revisit this piercing the attorney-client privilege because of the crime fraud exception. And I've had that issue come up a lot, too, because I get involved in a lot of these cases where someone has a tax attorney and they say the tax attorney was not giving advice about historical things that the client did, but was actually helping the client cheat on his taxes prospectively. And therefore, the client was using the attorney, wittingly or unwittingly by the attorney. The client was using the attorney to commit a crime, and therefore the judge has ordered that tax lawyer's file turned over. I'm the later criminal defense attorney who challenges that and says, no, there wasn't a proper basis to pierce the attorney-client privilege. You should not allow that file to come in. You shouldn't allow that tax lawyer to testify. And what comes up in those cases is that the government has to make what's called a prima facie case, which is to show the judge that there is some reason to believe it, because they can't just run around and grab every lawyer's file. And then if there ends up being something incriminating in there, say, aha, you see, what was in there proved my case from the beginning. That would be a prescription for disaster. But unfortunately, those hearings are done ex parte in camera, as was done here. And so the defense is not heard from. The upshot of all of that is that there will be an opportunity for Trump's lawyers to appear in front of Judge Cannon down there in southern Florida, and argue to her, no, the judge in Washington, D.C. was all wrong. There was not a prima facie case. And basically, that will be something they can renew. That would be a big loss for the government. If the government cannot get in Corcoran's testimony, they also can't get in Corcoran's notes, which are very detailed, how Corcoran was basically jerked around and he was forced to play hide and go seek. He certified that there was no national security information in all the boxes, but he wasn't being shown all the boxes. The valet had actually not shown him 30 of the boxes at Trump's request, so that he could falsely certify, as he allegedly did, had this underling of his also do, that they had gone through all the boxes, that a diligent search had been made, Kim, and that everything had been turned over when they come in with a search warrant after that in August of last year. And of course, famously find over 100 national security documents still with their national security markings on them.
It's outrageous. It's just really outrageous to me.
Well, they'll be able to relitigate that, you see, and that's what the delay will be. They'll also be allowed to litigate all these issues under the Classified Information Act. So one of the reasons the valet got a 2-week delay for everybody was supposedly with all Trump's money and knowing this was coming, the poor valet couldn't find a local counsel to be his lawyer. It's terrible when people can't find lawyers with all the money in the world and all the lawyers in the world. But he needed another 2 weeks, and I'm sure he'll need more time, and everybody will need more time. And then they'll have to make sure that the lawyers have clearances, high-level clearances. I had one when I was in the government, But it's not normal that lawyers who weren't assistant U.S. attorneys or who don't do a lot of work like this have ever had a national security clearance. So the lawyer will, if he doesn't have one, she doesn't have one, will have to go get one. And then there's something called gray mail in these cases. And the idea was that if you didn't like the deal that the government was offering you, you could hint, hint, wink, 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 indicate that you were going to bring out these confidential national security documents in court. You had a right to confront the evidence. The jury ought to see these things. And so there are laws that, they say that the not too hot. If a document is too hot, the national security people say, Kim, it's too hot to even come into court. I'm sorry you need to throw your case, but it's too hot. If it shows where nuclear silos are, too hot.
No,
and so if Trump held on to stuff like that, too hot. And then there are some things that are too weak. They don't sort of make the case. If somebody met with somebody and it was reported in the news anyway, people are going to say, oh, come on. You're making a mountain out of a molehill. So you got to find the ones that, what's it, Goldilocks? They're not too hot and they're not too cold. They're just right, that show the national security implications, show that the person should never have had something that confidential with them. They should have sent it to the National Archives or left it at the White House, but that are not so weak that people poo-poo the case. So all those motions are going to be heard. And the reality is that Cannon can delay this case. If it were a normal case and it weren't Cannon, I think that the case involving all this national security issues and the other issues in the case, wanting to raise prosecutorial misconduct, wanting to raise this, even if there's nothing to it, you got to have evidentiary hearings. I mean, there are many, many cases in which prosecutorial misconduct is alleged and very few in which it's shown. But again, it can take a lot of time. And if you have Trump's money and the motivation that he has, Kim, I don't see this case going to trial before November 2024.
Katz has spoken, November of 2024. And
After.
that kind of, after that, but that puts this whole thing kind of playing out during the campaign. And I had read
it won't
something
play
about
out. What's going to happen is if it's a Republican, him or some other Republican he's thrown his support to, they'll pardon him and the valet, the lucky valet. That's why the valet won't flip. The valet's waiting around for his pardon. All those people in the January 6th case who are in jail right now, they're waiting for their pardons. The Oath Keeper, the Proud Boys, they're waiting for their pardon if Trump gets back in. And if Trump doesn't get back in there, and it's Biden, let's say, for another 4 years, Trump's political career is over. He'd be over 80 after that. He'd be looking around to make a deal at that point, but not now. Not now. He wants to delay all these cases, even the two that may come down in the future. And he's got pretty decent arguments. I mean, you take this one down in Florida, it really does involve a lot of issues. This case normally would not get to trial in a year.
I want to flip over back to the New York case. You had mentioned a bit about it earlier. And apparently the lawyers for E. Jean Carroll are going back and saying, listen, we know that she had $5 million coming to her. We'd like to increase that to $10 million because of all the stuff Trump has said after the trial.
I think that there is actually a basis for that. There's a part, it's so complicated, but there's a part of this case that's still kicking around because Trump's argument is that he had protection as a president. As a president, he had a right to comment. And so some of the comments are going through all that appeal, and they're still in front of this federal judge, but they're pending. And so what she did was she added to the pending charges this request for more damages because she's been hurt even more by the famous speech he gave the next night on CNN, where he denigrated her again, and according to her, defamed her again. And having heard it myself, it did seem to me like it was defamatory and completely gratuitous. Whether he can collect from her. Mark asked me that question. How can she not collect from him? But I just assume that he's got a lot of money in trust, that he's got it, in different places. He's got it in some places that are kind of safe havens for not paying your creditors. But I think that after November 2024, I don't make political predictions, so you can't count this one. But I think that his support really has gone away. I don't see how he can win the swing voters. And so I think if they nominate him, he'll go down to a crushing defeat in 2024. And after that, he's all about himself. After that, he's all about not going to prison, not ending his life in an orange jumpsuit, and paying as little of those awards as he has to, but paying something. He did pay $25 million in the
Yeah.
Trump University case, he settled a lot of his cases for a lot of money. I'm always a winner. Yeah, he's always a winner, except when he pays off these huge awards, like the $25 million that he
Yeah.
paid to get rid of the Trump University case.
I know our time with you has come to a close, but you mentioned, how do these swing voters stay with him? And I just saw another poll pop up, a Quinnipiac University poll showing Trump with a 30% lead over Florida Governor Ron DeSantis among Republican candidates. So at this point, even in the most recent polling, it looks like people are staying with him in that GOP base.
Well, it helps him too that there's a proliferation of Republican candidates, the same advantage he had in 2016. And so, Pence is very popular with the right to life crowd, the anti-women's choice crowd. So he hopes to get a big share of the vote in Iowa. And DeSantis, he's attacking the quote woke mob. And so, there they are. They're going to get this much and that much. And then if Trump ends up winning and then he goes to New Hampshire and he wins, he's on his merry way. Then it goes down to Florida. He beats DeSantis. And, I think DeSantis could have really coalesced support around himself. But I think just looking at it politically, and I'm not a political scientist, but just reading the newspapers, looking at the news, I think DeSantis really just made a bunch of blunders.
David Katz, we are so lucky to have you. We really are. Thank you for the conversation and thank you for being here.
Great to be with you, Kim.
Have a great rest of your day. David Katz.
Hi, it's Mark, and I thought that was great. Hit the notification bell, you'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.